A very warm welcome to everyone joining us for this, the first lecture in the module on international law. In the early 1970s, Professor Upendra Bakshi wrote and presented a paper on the teaching of international law in India in the 21st century. It was reproduced in the 1980s in an edited volume titled New Horizons. The thoughts remain apt today. I quote, "A subject called international law has ceased to exist. The 60s and 70s have witnessed an evolution of new domains. The law of human rights, international business transactions, the law of the sea and of the outer space, the law of disarmament and of the right to development. International law is one label but many subjects. No one may legitimately claim a specialization in international law as such." Bakshi suggested that the courses on public international law be abandoned at the LLB level and that its contents be distributed as topics among other courses in the law school. Such a radical change lies within the purview of the higher bodies in our university system. But we may design our courses on public international law to stress upon its basics in depth, instead of providing the student body with an overview of the widely spread out domain as most textbooks do. Over the course of this module, I shall present some basic ideas of international law. These are topics which are often overlooked and termed introductory, but they are basic to a sound conceptual understanding of the field. In the introductory session today, I pick up the definition of international law and attempt to flag the various conversations possible around it. For this purpose, I shall use two definitions. One, given by Lasse Oppenheim in the early 1900s, and the other by J.G. Stark in the last decade of the 20th century. The key takeaway for this session is the need and indeed the possibility of making different parts of the course speak to each other. Cross-referencing one topic with another helps impress upon our students the existence of knowledge as a web rather than a linear presentation of information. Coming to the first definition, Oppenheim stated that international law is the name for the body of customary and treaty rules which are considered legally binding by civilized states in their intercourse with each other. Almost 100 years later, Stark noted that international law is that body of law which is composed for its greater part of the principles and rules of conduct which states feel themselves bound to observe and therefore do commonly observe in their relationship with each other, and which includes also rules of law relating to the functioning of international institutions or organizations, their relationship with each other, and their relations with states and individuals, and certain rules relating to individuals and non-state entities, so far as the rights and duties of these entities are the concern of the international community. We can use these definitions to discuss a number of things. For instance, the sources of international law. Whereas Oppenheim speaks of custom and treaties specifically, Stark's silence permits us a journey into the entirety of Article 38(1). We may venture into the hierarchy among sources and the presence of the word successively in one of the earlier versions of the statute. This difference between the two definitions, separated by almost 100 years, shows the evolution in the discipline. It allows us to speak of hard and soft law. It permits a conversation around the status of General Assembly resolutions as a possible source of international law. Speaking of General Assembly resolutions permits us to venture into conversations around the Third World and its contributions to the development of international law, like decolonization, on which the General Assembly in 1960 made a declaration without a dissenting vote, recognizing that all peoples have an inalienable right to complete freedom and proclaimed the necessity of bringing to a speedy and an unconditional end colonialism in all its forms and manifestations. Equally, we could also look at the idea of permanent sovereignty over natural resources, or the struggle against apartheid, or for self-determination, all issues of great importance led by the Third World. We could also use these definitions to speak about an entirely different topic of international law, its subjects. Whereas Oppenheim only speaks of states, the modern definition by Stark is more open to recognizing a whole host of non-state actors. We could use this to move into an entire conversation on a variegated approach to subject categorization, introduced by the International Court of Justice in the reparations case of 1949. Alternatively, we could discuss the hegemonical theoretical paradigms apparent in the definitions based on the time period from which they come. The difference in the use of the word rules in Oppenheim's definition, as opposed to the phrase principles and rules in Stark's, is worth pointing out to our students. This movement is caused by a move from exclusive legal positivism of Austin to a post-Fuller hard work and understanding of law that they have studied in legal theory. This will help them see learnings from jurisprudence in practice in international law, and the learnings of this aspect of the definition of international law will be seen in practice when they come to study subjecthood later in the course of international law. Speaking of positivism, we must also turn to the term civilized used in Oppenheim's definition. How does one understand the term today? It is important to answer this, as the term continues to find space in international law. Only if we understand it can we react to its continued presence in, say, for example, section 38(1) of the Statute of ICJ, which reads that the court shall apply general principles of law recognized by civilized nations. What does this mean in today's world? To answer this question, we turn to another stalwart of international law from India, Professor R.P. Anand, a pioneer of TWAIL who worked at the Center of International Legal Studies at JNU. He notes that the term only came to dominate the international legal space in the late 18th, early 19th century as the rapidly industrializing European nations started to disregard previously noted sovereignty of the Asian rulers. To make his point, he points us to the 1779 treaty between the Maratha Empire and the Portuguese, which has been recognized by the International Court of Justice in the right of passage case as a valid transaction in the law of nations. Anand notes, this development of provincial outlook in Europe led to leading writers of the 19th century and the early parts of the 20th century to assert that international law is applicable only between civilized and Christian people of Europe, or to those of European origin. However, once the Japanese defeated the Russians, a Christian, white European power, in the first decade of the 20th century, they too came to be recognized as civilized. Anand notes that the chief criteria of civilization at this time was power. Today, the meaning of civilization, as synonymous with the Christian Western civilization, or with the power to advance its frontiers through the focus on industrialization, has been rejected. Any nation willing and able to carry out charter obligations is a civilized nation. Thus, we can see through the definition of international law, one can study so many different things. One can talk about sources and subjects and positivism and even the term civilization, all of which form the basis of international law. In the next session, we shall look at the relevance of international law. Thank you.